Good afternoon, friends. Let us dive into another leading case which is in the syllabus of Advocate on Court Examination of Supreme Court of India. This is my 16th video on Advocate on Court Examination. In this video, I will share with you one of the leading case, that is Pradeep Kumar Biswas versus Indian Institute of Chemical Biology 2002. Friends, in this case, the issue was relating to which company, which organization can come under the parameter of state that is defined under Article 12 of the Constitution of India. Why the differentiation has been done that particular comes under the definition of state under Article 12 and another one does not. It is because whatsoever comes under the Article 12 and is known as state, that comes under the judicial review of the honorable courts. So writ can be filed against them. So in this case, the issue is whether the Council of Scientific and Industrial Research, shortly known as CSIR, a body established by the Government of India, qualifies as a state under Article 12 of the Indian Constitution. Article 12 defines the term state for the purpose of judicial review, including the government and local authorities. What is the background of this case? Pradeep Kumar Biswas and others, so many other persons were there. They challenged their termination of their employment by the CSIR, arguing that CSIR, the action could be reviewed under writ jurisdiction because it was state under Article 12. The High Court had dismissed the petition based on the precedent set in the Sarbjit Tiwari case of 1975, which held that CSIR was not a state and thus could not be subject to writ jurisdiction. So, after the dismissal of the writ petition by saying that it does not come under the definition of state under Article 12, as it was there was already decided case that was Sarvi Twadi's case. So before Supreme Court, Honorable Supreme Court, two issues arise, two legal issues were there. First one was whether CSIR, a body created by the Government of India, could be considered a state under Article 12 of the Constitution. Second issue was whether the Savajit Tiwari judgment should be revisited considering the evolving nature of the government bodies and their functions. These two issues were there. Honorable Supreme Court analyzed the things. As society is developing with time, the definition also changes. Earlier, if the corporation is not coming under the definition of state, later on it may come so, keeping in view the so many other circumstances. So the court looked at several aspects. First one was financial control. CSI was largely funded by the government. Over 70% of its budget was from the Government of India. Then administrative control. The government has significant control over CSIR's functions, including appointment of its governing body and approval of its bylaws. Third was for what function it was created and what is it doing now. Then mean to say public interest. CSI was created for national development, including scientific and industrial announcement. So the Honorable Supreme Court gave its judgment. Firstly, it overruled the decision in the Savajit Tewari case, holding that CSIR, due to its extensive government control and public welfare objectives, fell within the definition of state under Article 12. This meant that CSIR was subject to judicial review and that petitions could be filed against it. The ruling emphasized the need to recognize bodies like CSIR created for public welfare and largely controlled by the government as entities that should be held accountable through writ jurisdiction. So, this judgment is significant. Why? This decision expanded the interpretation of state under Article 12, affirming that public bodies, even if they operate under a nominally independent structure, could still be subject to judicial oversight if they are heavily funded and controlled by the government. It underscored the importance of ensuring accountability in public bodies, even though working in scientific and industrial domains. The ruling also set a precedent for other similar organizations to be considered state under Article 12, thereby making them amendable to writ jurisdiction for the protection of fundamental rights. That's all. God bless you all. See you again in next video on next topic relating to advocate on record examination.